go ahead and jump in today. Okay, hit record. Okay, so we're just going through an overview of the changes that are coming with the new guardianship and conservatorship law. Just some quick background. The Uniform Law Commission is a national group that puts together proposed legislation for all kinds of things. There have been some other related acts that have been circulated and adopted in the past, including the Uniform Adult Protection Jurisdiction Act that helped states recognize guardianships and conservatorships from other states instead of having to start all over or have competing petitions in different states. This particular law, which has been lovingly referred to as UGCOPAA, the UGCOPAA, the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act, was originally published by the Uniform Law Commission in 2017. TEPI, that Bob has headed up, and Becky was a big part of the review of this, took that uniform law and that group spent multiple years going through and not just decoding, but also figuring out, rather, you can't just take a piece of legislation and just adopt it without understanding how it's going to interface with other laws that are already on the books, which is part of why this legislation was, is it 117?
111 pages.
111 pages. Most of that is basically integrating things from other existing code. And this combines, so guardianship, conservatorship fell basically in three different sections in Idaho code. There was a section for minors, there was a section for adults, and a section for adults with developmental disabilities. And so this was trying to integrate all of those pieces together so there's more consistency about the rules and requirements. And also that group, including TEPI, there was also participants from other interdisciplinary areas providing input. So we had people from health and welfare and disability rights advocates that were coming in and providing a lot of meaningful input with the changes that were being proposed. So at a glance, this is repealing and replacing Idaho's existing guardianship and conservatorship statutes and adopting the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. Basically, this is modernizing Idaho law to strengthen individual rights, increase court oversight and accountability, emphasize least restrictive alternatives, and align Idaho with national best practices. So even though this uniform law has been around since 2017, there's still a surprisingly small number of states that have actually adopted this legislation. So believe it or not, even though we're now 8 years into the process, or almost 9 years into the existence of the act, we're still going to be one of the early adopters compared to other states. So good job, Idaho. Philosophical change and approach. There was a lot of things that changed. A lot of things that were changed had to do with language and structure and emphasis. A lot of language being updated, trying to remove some of the archaic terms that were a little more dismissive or demeaning towards the person who's subject to guardianship. And also just trying to change that we're trying to move away from full guardianship or conservatorship as just a default, trying to emphasize and trying to move away from some of the limited procedural safeguards that were in place previously, and moving towards more of a presumption of self-determination, that the default is not the presumption that the person needs a guardian, The default is now, or what we're moving to is, the assumption is the person doesn't need a guardian or a conservator unless the court receives sufficient information to make that determination. And also mandatory consideration of less restrictive alternatives. And some of that language was already in our existing statute, but it's even more robust now in the new act. It is rights focused and the court orders that are issued under the new act are intended to be more rights focused and more individualized. So rather than having just generic orders that will look the same on all of the cases, they should have more tailoring to the needs and circumstances of each person.
Paul, can you give maybe just a couple of examples? What does that look like, at least restricted?
So we'll get into that a little bit, but least restrictive is basically what's that balancing act of the extent to which a guardian needs to intercede or be made that, a delegate for the person, versus what are they able to still retain as far as independence and decision making. But we'll talk a little more about what are some of the forms that's going to look like. So moving to more consistent and clear evidentiary standards, which the primary thing is moving to clear and convincing evidence as opposed to preponderance, or I'm not an attorney, so I can't clarify exactly what that means. So if somebody wants to just kind of quickly run through clear and convincing and how that standard differentiates from preponderance or other legal standards. Bob, you're probably best to address that because I called on you as you took a bite. So yeah.
Yes, anything that has to do with fundamental rights requires very convincing evidence. Things that don't deal with individual rights generally are going to be preponderance, but some of the statutes will give it more likely than not type of interpretation. And the court has to find, before you can go to a full guardianship or limited, they have to find first by current convincing evidence there was no ability to use supported decision making. If that didn't work, couldn't work, then you go to powers of trust. If that didn't work, can't work, then you go to the new part of this part 5, we're talking about protective arrangements. Mm-hmm. If that doesn't, it couldn't work. And remember, these are all clear convincing evidence tests. Then you go to limited. And if that can't work, clear convincing, then you go to full guardianship.
So I think one of the ways that's going to look different is, I know we've had in the past a lot of cases that have really been decided on the merits of the arguments in the original petition given to the court. And the court just looks at the petition and makes a judgment call based on the information contained in that petition without gathering outside corroborating evidence that backs up the allegations in the petition. So that was one of the risks that made the system more efficient, because decisions could happen more quickly. But there were also instances where guardianships were being imposed that maybe weren't really justified or maybe not really necessary, because the system just was probably a little designed to be more efficient than accurate, I guess. Maybe that's a good way to say it. So also now requiring mandatory notice for certain things, mandatory participation of the person subject to the guardianship proceeding, and the right to counsel. Some changes happening with the guardian ad litem role. My understanding is it's not completely going away.
Well, the guardian ad litem works when you have a child under 12.
Okay.
Or when they're a child over 12, less than 18, but can't work with an attorney.
Okay.
With maturity, or an adult who is unable to work with an attorney.
Okay.
That's the uses.
Okay. So a guardian ad litem is going to be more limited in adult guardianship actions. Basically, that will be where essentially you've got somebody who's who's either absent, because there are conservatorships. We've dealt with some conservatorships of missing persons, where we don't know where they are, but they have assets that need to be dealt with, or if you have somebody who is so gravely incapacitated that they can't participate with an attorney and give them direction about their preferences and desire to have their position advocated for. So it is going to move to more attorney involvement as an advocate for the person and their wishes, which I think we've seen in the past that some of those proceedings are a bit more collaborative, and we may see more contested proceedings as a result of that. But the hope is that the offset is we are making better decisions and that the courts are being more thorough about allowing the person the right to be able to voice their opinion, voice their preferences, and to have that heard by the court rather than everything kind of happening behind the scenes without the person really being involved or having an active role in what's going on.
That's a quick question.
Yeah.
For this, but does that mean that the judge isn't going to automatically assign a GAL at the time that they're setting the hearing date any longer?
That's my understanding. So, and when the petition, then all of this is going into effect starting in January. So we've got a few months to kind of sort some of this stuff out. But as Bob said, the GAL role is really going to be pretty limited now in adult guardianship proceedings. It's really going to be relegated primarily to minors. So the court can still appoint an attorney, and a court-appointed attorney is more like somebody who's being individually represented. And so the attorney is representing that person as their client, which is a different role than philosophically how guardian ad litem role was used in the past. That also means we're not going to get a guardian ad litem report submitted to the court, which was one of two reports that were required before. You get a guardian ad litem report and you get a court visitor report. And now that GAL report may not be there. So we'll see. Again, I don't know functionally how all of this is going to shake out and what it's going to look like. We'll see. Obviously, between now and January, there's going to be a lot of education and training sessions with the judiciary and court personnel on how's all this going to work and what are we going to do in some of these situations. But a good question. Thanks, Marika. Court visitor is still going to be there. Yes.
And evaluation committee.
And evaluation committee in DD cases. Yeah. So that's not going away. It's just, again, being brought all under the same umbrella instead of being in different places in the statutes. We now have the creation of protective arrangements as alternatives, or we will have, and more enhanced monitoring, reporting, and grievance processes. So some of the guiding principles in the new law, and they really are echoes of what we've already kind of been moving to. It's not like any of this is really brand new, but some of the specifics are going to be a little different. Least restrictive alternative, that's been in our statute for a long time, that guardians are supposed to be looking for the least restrictive alternative for the person. That balancing act between safety and self-determination. They may want to live in a certain setting, but it's just not appropriate, and that's still going to be the case. Supported decision making is the preferred format for people as an alternative to guardianship. So, and supported decision making, again, the history on that goes back a long time too. That really primarily came out of the DD movement and as a way to try to help restrain that automatic pipeline of people with developmental disabilities getting out of high school, becoming an adult, and being told, their parents being told, well, you need to go get guardianship of your child now, and trying to move away from just the automatic assumption that somebody with disabilities required a guardianship in order to protect them adequately. And So supported decision-making is an informal support system. It's a formal support system where the person has written agreements with certain delegated parties that give them input and advice on certain areas of decision-making, but the decision-making is still being made by the person. So they have this circle of trusted advisors, but it's still about them and what they want to do ultimately. Which again is very capacity dependent and sometimes circumstance dependent. It may be that there's certain areas where supported decision making works great and other areas where it doesn't, because there may be certain things that are just more complex than what the person is able to really fully process. It's kind of like the informed consent idea that you have to have the capacity to provide informed consent, and if you don't, you can say yes, but that's still not informed consent. So supported decision making is supposed to be a preferred alternative when that is feasible and the supports are available that would be successful for that person. Individual participation required. We are going to see the expectation that people are going to be attending hearings for guardianships unless there is significant cause for them to not appear at the hearing. So either appearing in person or appearing via video like Zoom, unless the court finds that it's either not feasible or the person has a pattern of refusing to participate. So there has to be some significant reason why the person isn't participating in those. And retainment of rights is now the default rather than rights being taken away by default and having to be specifically retained in the orders in order for the person to retain those rights.
Question.
Yeah.
So I'm thinking about your guiding principles like supported decision making. Is that a substitute for guardianship? Like the court will not issue a guardianship order, but instead these people are just going to work something out on their own?
You don't actually need any court involved.
There's no court
The whole idea
involvement.
is that
Right.
Something person sits down and organizes themselves, no court.
But before filing a petition for guardianship, you need to be able to address why supported decision making or other alternatives aren't sufficient and won't work for the person. Yeah. So I don't know that we're going to see that the court is going to order those kinds of arrangements. Although I think we could see the court deny a petition for guardianship and say, I don't think guardianship is necessary. I want to see supported decision making tried for 6 months or something like that. So I don't.
If you try it for a month or two, and sometimes it's only a month for some people if they really lack capacity and they're not able to participate, then you would move to going to court.
No, you move next to powers and trust. You move first to powers and trust.
Okay.
Can those either exist or already created or can be now created? And that's to be used first. So don't take away those rights, because you can now use our existing power and trust potentially for assets.
Okay.
And again, all this has to be in the petition.
Right.
The petition itself has to say, here's why supported decision making did not or could not work. Here's why powers and trusts did not, could not work. Etc. Up that chain. So the petition lays all of that out in detail with supporting. We're no longer, as Paul said, going in and just, yeah, sounds good. You wrote the right words, boom.
So if they don't have any power of attorney, then
Do they have capacity to create it?
right.
Yeah.
So how would that be determined?
Well, somebody's going to have to create that, and then it's going to have to be signed. If you're an attorney doing that, if it's in some kind of question situation, you should, and the standard practice is to go to an intense amount of determination.
Okay.
Part of that medical, but medical people don't make legal types of determination. A lot of it is just meeting with a person and finding out, can they do logic?
Okay.
Can they do simultaneous and sequential? do they know the things? Not the mini memo, for God's sakes, but do they have capacity and have to be satisfied with that? That's part of what we'll be training attorneys on. If you do powers, they're a good alternative if you can do it.
Okay.
And
That sounds
ideally,
good.
those are already in place. And again, that's part of, anybody that's involved on the estate planning side too. It's like, this is part of why that estate plan is so important, because by creating those power of attorney documents in advance, it is one way to help avoid guardianship from becoming a necessity in the first place. So again, court orders need to be specific, individualized, and evidence-based. This is going to put a lot more burden on the attorneys that are drafting those orders to figure out, again, how are we tailoring the orders for the guardian and for the conservator to make sure that we are within the narrow scope of what is necessary in this particular case. So we can't just use boilerplate for everything. Again, legal standards, the court can only appoint if the individual cannot meet essential health or safety needs, including they are unable to receive or evaluate information or communicate decisions, and less restrictive alternatives are insufficient. And this also includes, so as Bob talked about, so we've got supported decision-making as one of those alternatives, powers of attorney, as one of those alternatives, creation of a trust and a trustee role that could serve in certain capacities, but also clarifying that supportive services, technology, or decision making are not effective substitutes. So again, this is really more, I think, stemming from the disability rights area, but also can be appropriate in older adults that are dealing with mobility issues, sight issues, any other deficits where now maybe there's adaptive technologies that could assist them with either expressing or being able to understand information about their condition or about their options. So I just thought it was interesting that that's being written into the new statute, that we need to look at, are there ways that we can adapt the way information is communicated, or what things can make it easier for somebody to be able to understand the information that's being presented to them. And again, full guardianship. So if the less restrictives are not sufficient, then the next step is limited guardianship or limited conservatorship. And if limited isn't sufficient, then again, we can't just say it's not sufficient. We have to explain to the court why it's not sufficient before we say, okay, we are recommending a full guardianship. I think in practice, I mean, we've had these discussions for years about, well, we really want to go more towards limited guardianship or limited conservatorship. It's just that a lot of those cases where if we could have avoided guardianship or avoided conservatorship, there's probably one of the other alternatives that was sufficient in place, or an informal support system that was functional that didn't require the intervention of guardianship. So I don't really know realistically how many limited versus full we're going to see, but the theory is by making it more specific that we have to address why it wasn't sufficient, then it's going to be up to the judges on how they're going to make that determination. And of course, training judges is a challenge all to itself. And I think we'll probably see that again, depending on where you're at in the state, where there are more cases like Ada and Canyon County versus other more rural jurisdictions where you've got one judge that's hearing all kinds of matters and doesn't really have a lot of understanding or experience in the guardianship world.
We will be creating cards, they're called, for the judge.
Right.
That walks them through all the steps.
Yep.
And they have to check off.
Okay,
before they can move to the next step. So again, limited, you can't just say, number one. Number two, the court has to say, I found by clear and convincing evidence. Not just somebody said.
right. So it'll be interesting to see how that gets fleshed out. Like, how do you provide clear and convincing evidence that this limited guardianship didn't work? Jamie?
So the what I'm hearing in my head sounds like because a lot of times I'm contacted by the hospitals or by medical providers that have a patient in the hospital and they're saying, hey, the doctor says this person, excuse me, incapacitated. So then what I would go back to them with is, hey, I need to know, are you thinking full guardianship? Are you thinking limited? Why are you thinking it? And then when they write their doctor's letters that we submit to the attorneys to submit with the petition, that's where we need to start. That's what I'm hearing.
Yes, and more. So there's another part that we'll get to in a little bit. But yes, that's actually a specific area that they're trying to reduce the commonality of, is, you know, this thing that they call the healthcare to guardianship pipeline, which, you know, there are people in those situations. We all get those calls that there's somebody in the hospital, they don't have capacity, they're not safe to go home, and so we need a guardian in order to get them out of the hospital. And this law is providing for more alternatives for how that can be done without imposing necessarily guardianship for life after that. Some interesting things that I observed, this is not exhaustive, but just looking at petition requirements, we now have to have the name and address of the petitioner, name and address of the respondent or the person who may be subject to guardianship. I'm using respondent and person kind of interchangeably in here, but any spouse, or if there was an adult living in the household 6 out of the last 12 months, that person needs to be named in the petition. If there are any adult children of the respondent, if they don't have adult children, then the parents and any siblings of the respondent need to be listed in the petition. Adult stepchildren that were parented as minors and have an ongoing relationship with the person during the last 2 years before the guardianship petition. So again, that I thought that's interesting. We see lots of blended family and marital relation type scenarios, but I thought it was interesting that specifically stepchildren only get granted status automatically if they were still minors when the person subject to the proceeding was their step parent, and that they have continued to have a relationship as adults. Becky and I have seen so many cases. Well, all of us have seen so many cases of remarriage, and biological children do not get along with step parent at all, and lots of conflict that comes out of that. Again, if the petition is seeking a full guardianship and conservatorship, there must be a full explanation as to why that is the appropriate remedy for this case. Petition and notice must be served personally on the respondent. However, failure to serve does not preclude an appointment by the court. That's actually a really interesting thing, because service has been used. I've seen in some cases, if the petition and notice of hearing wasn't served on the person personally within a set time frame, I've seen some cases that got dismissed and had to be refiled. So this change actually now, it still requires, it needs to be served on the person, but it's not a fatal flaw that would prevent the court from making a decision if they felt like it was still appropriate, even if that service was not provided.
It's also your missing person.
Correct. Also, if the person is unavailable by means of being missing for the conservatorship side. Let's see. And also needing to include any requests for orders to preserve or apply property while the proceeding is pending. So, yeah. So if we're trying to restrain
Are you on your way?
using assets, or if we're trying to
Okay, where are you?
ensure that somebody is using the Let's see. So emergency appointments, oh, I'm sorry, Lane, go ahead. Yes.
A lot of you know the lingo, but if you're talking to a family member and they don't know whether they need, is there a separate petition for limited versus full? How are they, how's the petitioner gonna know? Like say they're a concerned family member, neighbor, whoever,
Well, the
or
attorney.
even myself, or is that decided by the judge once he's got all the evidence and information?
Well, if you're a responsible attorney,
The attorney
you-
that's working with you on a petition.
yeah, so if you're a responsible attorney, following what you should be doing, that conversation happened before anything was going to be filed.
Okay.
You told the family, have you tried? Have you tried? Have you tried? Because those are tests that have to do that. And someone will be automatic. Person's in a coma in a hospital bed. Yeah, you're going to go to full. But somebody's out in their home dealing with things, having some problems in bits and pieces. You start with that, support it, and all that goes through. And the attorney should be laying that out and saying, you got to do that first before you even come back and talk to me.
Okay, so that's not necessarily on the petition form per se.
Well, the petition form says we tried all of those things. Here's clear convincing evidence to prove that it either didn't work or couldn't work. And if you don't have that in the petition, the court's going to say, you're toast.
Okay, gotcha. Thank you.
All right. So emergency appointments, they changed some of the language for what meets the standard for an emergency appointment. So emergency appointments now for guardian are in order to prevent substantial harm to health, safety, or welfare of the person, or on the conservator side, substantial or irreparable harm to property or financial interests. There's no other party willing or authorized to act, and there's reasonable basis for the petition of a guardianship or conservatorship in, again, whether limited or full. And in an emergency appointment, the guardian or conservator can only act within powers granted under those emergency orders. So again, the powers have to be specified in the order what the guardian or conservator can or cannot do under that limited authority. 90-day limit to emergency appointments with only one 90-day extension allowed by statute. So I know we've all seen cases where it's like temporary just continues on for a year and a half or 3 and is never really decided, and that's not the intent. The point is, maybe if the person can survive with a temporary guardian or a temporary conservator for a year and a half, maybe they don't need one. So sometimes it's just that it's a slugfest and people are arguing about who's going to be in charge of what, and that's just part of the fun of family drama. Rights of persons subject to guardianship and conservatorship. They have the right to attend hearings, again, in person or via video. The hearing may not proceed unless there are certain exceptions met. The person can select the supports of their choosing. So they have the right to have whoever they want to provide assistance to them in those hearings. They have a right to counsel.
That may be language, by the way. Yeah, somebody that speaks very little English, but speaks, for example, Spanish or something else, you have a right to a translator.
Correct. Yep. Yeah, we'll see how some of this gets interpreted in reality. Yeah. Let's see. The right to counsel. So again, because you don't have a guardian ad litem being appointed, the person has the right to seek individual counsel to represent them. It's very unclear at this point if the person doesn't have the resources to pay for counsel, how is that cost going to be covered if it's allowed under the, so there's a question of whether or not that's going to end up rolling into public defenders as representatives for these petitions, particularly where it's just for guardianship with somebody with de minimis assets that doesn't require conservatorship. We'll see how that works. The person still has the right to object or request a modification of the guardianship and conservatorship. They have the right to communication and the right to have visitors. The right to participate in decisions about things like their care, their dwelling, their activities, and marriage rights are retained unless specifically removed. So some of the changes, well, not changes, but some of the clarifications on guardians' duties and limits, and just trying to get through this quickly because we're going to run out of time, I'm afraid. So the guardian duties: promote independence and self-determination, use substituted judgment whenever possible. And again, substituted judgment is making the decision the person would have made if they were still making the decision themselves. Act in best interest only when preferences are unknown. So the highest standard is substitute judgment, where we're making the same judgment based on what they would want, not imposing our own value set on what we think of their decisions. Acting in their best interest, again, only when we don't know what they want. A requirement to monitor their care, their living conditions, and services being provided. A duty to notify the court when capacity improves. And this is a really important one: no power to amend or revoke a pre-existing power of attorney. You must defer if you're a guardian and there's somebody with a healthcare power of attorney. You must defer to the healthcare power of attorney unless we seek a court order to have that power revoked. I know that seems illogical. However, that's how this. So I think the theory is the person knew who they wanted to appoint to make those decisions for them. They trusted that person. Whether they are ultimately trustworthy is a different issue. But the issue is, are we deferring to the wishes of the person? If they have those pre-existing powers, then the court doesn't want those just being automatically overridden by a guardian or a conservator. Court approval is required for marriage or divorce actions, sterilization or reproductive impacting treatment, experimental treatment, restricting communication beyond short emergency limits. This is a big deal. So if there is somebody who is a pain in the neck, you can only restrict them from communicating with the person for up to 7 days for people who are family members or have pre-existing relationships with the person, and up to no more than 60 days for others that aren't family members or don't have pre-existing relationships with the person. And again, so past that, you have to get approval from the court or an order from the court to restrict that relationship. That I can see that being a big hornet's nest. Yeah. I'm just saying that and mostly this still goes back to the idea that it's the person's right to communicate to and have social relationships with the people that they want to have relationships with. I mean, as we all know, they are not necessarily functional people or healthy relationships, but if they, normal is in the eye of the beholder. What they think of as a normal relationship may not be what we see as a normal, healthy relationship. But unless we can show that, we would have to be able to go to the court to show that relationship may be, subjecting the person to significant harm, either physically, psychologically, or otherwise.
So if their visits after they left caused the person to be extremely distressed and have a lot of behaviors, that might be an instance where if you couldn't train or help that visitor to learn how to do things different, that might be something that you would need to ask the court for restriction of.
Yes. And the family members have more rights under the new law. So it was in the existing law, it was very much about who the person wanted to have communication with. In the new law, it is defaulting that family members have pretty strong rights to have access to the person. And that's not always great, as we know, but that's the the shift in the viewpoint. Yeah.
Just a quick question. So if we're restricting them, I would assume we're gonna have to know everyone's names.
Yeah, if we're going to be imposing by court order, yeah, we need to know who the person is.
Yeah, we have some clients that we know have unhealthy relationships, but they don't want to tell us the names of the people they're having unhealthy relationships with.
Yeah.
It's happening late at night when there's not supervision.
On the internet or whatever.
How do you?
Yeah.
We don't. How do you handle something like that?
I think we're going to see all kinds of crazy things that come up as a result of this. Because it's not just about people. It's also about people who, I mean, again, you know, you think in the world of scammers, it was bad enough when you had a person who was calling up and impersonating a grandchild or whatever. But now we've got people who are using AI agents to, and they are getting really sophisticated now. And, you know, we've got people who are going on dating sites and they are communicating with a person on this dating site that they are sure is a real person because they can see them and they can talk to them on this site. But again, it's all just AI generated. How do you get a restraining order against AI?
My immediate answer would be, you would say only the following people can visit and nobody after 10 p.m., whatever.
Okay.
You individualize it. What are you trying to block?
We don't need to get approval to have, you know, so some of my clients too, I say, you know, yes, you can visit, but it has to be supervised. We don't need the court's approval to initiate supervised visitation.
I don't know that I'd have to read through the statute more carefully to see how it addresses that. I don't think so. Because I think requiring supervision doesn't restrict the availability of communication or visitation. But again, if that can only happen under supervision, and yeah, then it's like, well, now are you going to bump into that like once a week? Are you willing to go supervise that phone call or that person's visit? Because we can't restrict it past 7 days without a court order.
And that's expensive if you have to go and supervise.
None of that is addressed in the law. Yeah, that is correct.
Did given or an automatic exclusion that if they're the perpetrator of either the financial or physical abuse, for instance, are they still allowed? Or is that an exclusion?
Well, no,
If they're named as like.
the only exclusion would be somebody who has a felony. So if
Well,
there's,
you can get a specific.
but you can, I mean, you can put it in the petition, like if there's somebody that you want to seek restriction at the outset, that can be part of the original proceeding, is to say this person is a danger or this person has been, you know, exploiting, or whatever it is. So that can be addressed in the original petition, but in like post adjudication, once the decision's been made, this person is subject to guardianship, and there's new relationships that get fostered, then they're going to have to be addressed on an individual basis. And I don't know that it's really been well thought through about how expensive some of this could get, because we know that, you know, those marginal cases are the ones that are the worst, because you've got somebody who's marginally of capacity and dedicated to all of these things that are terrible for them, but they're still going to pursue it full on. So it becomes, in those difficult cases, it's just going to continue to be difficult.
You, for example, might have at least temporary withdrawal of a phone or tablet or other access while you sort it all out. That's allowable. And you're having this happen when you're already into a petition for guardianship, where you have to have a lot of those facts laid out.
Right.
The court can tailor the emergency, if you need that pending file, to those specific situations. Or it may take a protective arrangement.
Yeah.
It might be one item, one thing.
But I think we're also going to really struggle, again, you know, depending on the caseloads of the courts, I think we're going to really struggle with how are we going to intervene in a timely fashion if we're 6 to 8 weeks out on a hearing date and we've got an issue of somebody that we need to restrict for more than 7 days. What do we do? Let them call and harass the person once a week? That just seems, you know,
Well, again,
so I think we're going to have to see what the tests are and how this is going to actually really play out.
So I have a question.
Yeah.
If the person, the protected person doesn't want to see a family member, then you can honor
Yeah.
that. You can support that.
Yes.
Yes.
Again.
Yes.
Is that in their best interest?
Correct.
Well,
But
siblings where there was an issue regarding parents' estate. The protected person hasn't spoken and other people are very aware of this. And the protected person hasn't spoken to the sibling in well over 10 years and will not even talk about them.
how many of these cases have we seen where people that have had no connection magically appear, especially when money starts
The
being
day
involved?
Court,
Yeah,
please, the day before court, everybody
Yeah.
thought he was dead.
yeah. I don't know. Again, I think we're just going to have to see how these play out in certain specific situations. I don't think we could ever create a law that is going to perfectly address all of those scenarios. So,
Oh, one more question.
Yeah.
Sorry. So is the expectation that cases that we already have placed restrictions on, that we're going back and petitioning the court to keep those restrictions in place?
that's unclear. So when the new law goes into effect in January, that is applicable to all new cases going forward, but it may be applicable to all pre-existing cases. Yeah. Okay, so just really quickly, because we're at 1:00 already. So notification requirements. This is a significant thing. The guardian must notify spouse and adult children by default unless the court determines contrary to preferences or not in the best person's interest. You must give 14-day advance notice in a change in their primary dwelling. So you must give actual notice to, again, any spouse or any adult children or other interested parties that are involved in the case. You must provide notice of any significant change in condition or the death of the person. And that notice must be given no later than 14 days after the change has occurred. What constitutes a significant change might be very different from your perspective as a guardian, as the family member that is expecting notification. Again, it's not defined in the statute. It just says significant change. So that may be an issue that you need to discuss with those family members at the early stages of the case, so that you're kind of on the same page about these are the kinds of things I'm going to notify you about. You must provide notice when you are unable to visit the person for more than 2 months, or if you are unable to perform your guardian duties for more than 1 month, then you have to send notice out to all of the parties. Which would be interesting, because if the reason why you can't do it is because you've had a medical emergency, I'm not sure how you're going to provide notice, but hopefully you've got support staff that can help with that. On the conservator side, prudent investor rule still applies for managing assets. There is now mandatory bonding for compensated conservators, which has not been the case in the past. It's just been the discretion of the court. Mandatory inventories, financial plans, and reports. That's really not different. Again, conservator doesn't have the power to amend or revoke a financial power of attorney without seeking court order. And boy, we've seen that have all kinds of fun. Must seek court approval for gift giving, other than de minimis gifts, like if you're just giving $25 to a grandchild for a birthday or something like that. But if it's any significant amount or significant property being gifted, that requires court approval. You must have court approval to sell a primary residence or surrender a lease of the person as their primary residence. So if they're renting a place and you're going to be surrendering the lease before the termination of the lease period, you have to get court approval to do that, to break the lease. Court approval to create a trust or any modification to estate plans or changes in beneficiaries. That would also include closing out bank accounts that have POD or investment accounts that have transfer on death on those accounts because that impacts the estate plans of the person. And court approval required for any conflicted transactions. I think we're probably going to see this more in the arena of family guardians and conservators, where maybe they've got a financial interest in a transaction. They are, they're the person is living in a house that they own, and they want to sell the house, and they're going to realize a financial benefit from selling the house. So there's various transactions that will require approval from the court. The conservator also has notification requirements now to, again, interested parties, including spouse and adult children of the person, 14 days prior to the sale of residence or surrender of a lease for the primary dwelling. The conservator also has a requirement to provide notice of a significant change in condition or death of the person no later than 14 days after the change has occurred. For some of us as conservators, that's going to be a bit of a challenge because we are not the guardian who is more likely to know about those significant changes in circumstances. So I'm not sure how that's going to play out when you have a guardian and conservator. Are both going to be required, or is it going to be, if it's just conservator, the conservator has to do the notification. If it's guardian and conservator, it's the guardian. I don't know. It doesn't really clarify that. Correct.
So you get notice from the guardian. That's probable step.
Right, but then I have to go and notify all the same people that the guardian notified.
No.
Well, according to the statute, I do. So
that's the default.
Right.
And if the notification has already happened, you don't duplicate.
I hope not. We'll see. I guarantee there will be a case that somebody's going to make that allegation that you didn't provide notice, and that's my breach of duty. So we'll see.
And the court will laugh at you.
I hope so. I hope so. We just need one case for precedent, and then we're okay. And then also, if a conservator is unable to perform duties for more than 1 month, interesting, they don't require the conservator to visit the person. If you haven't visited the person for more than 2 months, you don't have to send notice out. Compensation, the reasonable compensation and reimbursement for expenses standard is still the same, but the court has given more specific guidelines of how to evaluate compensation, the necessity and quality of the services provided, the experience, training, and professional standing and skills, difficulty of the services performed, including degree of skill and care required, conditions and circumstances under which services are performed, including whether or not they're outside regular business hours or under dangerous or extraordinary conditions. Yes, we have been there. The effect of services on the individual subject to guardianship or conservatorship. I'm actually really glad they were putting that in there now, because I know Becky and I have talked about that in the past, that there have been people whose lives we have vastly improved because we've had a guardianship and conservatorship in place for the person. And maybe it was pretty expensive to do all of that. But if you look at the net benefit to the person, we kept them in their home when they wanted to stay home, or we were able to protect them from somebody who was really negative for them. So that kind of context helps provide substantiation for those compensations. And the cost of fees customarily paid to a person that performs a like service in the community. Also, I'm sorry, the extent to which the services provided were or were not consistent with the guardian or conservator's plan. So again, at the outset or each year, you're supposed to submit a plan for the guardianship and a plan for the conservatorship. And the more detailed that is, the more likely that your compensation is going to be tied to that. So if you say, I'm going to do all these things, and you don't do all these things, then your compensation should reflect that. If you originally said, I'm only going to do this, but you ended up doing all of this, then that's going to be justification for changes. But we can't, but that's one of the things that the court's going to evaluate. Protective arrangements. So this is that other issue, Jamie, that you were talking about. What do we do in these situations where you've got somebody who is stuck in a hospital and they need somebody to do things for them on a limited duration and for a limited scope. And so these protective arrangements, these orders for protective arrangements or single transactions, can be done without having to impose guardianship or conservatorship. So a court can order specific financial transactions, like they can order the sale of a person's home in order to just, they have to do that transaction, but after that transaction is completed, then that's the end of that appointment. Limited authority over discrete issues such as placement in the community, because it could very well be that once we get somebody out of a hospital and into an appropriate care facility, a guardian isn't really necessary for them. They're now they're being provided the care that they need. So maybe we really don't need guardianship for everybody just because they're in memory care. Let's see. May order support without removing legal capacity. So they can order like a supportive decision-making arrangement, or some other supportive relationship with somebody without declaring the person incapacitated. And also either temporary or targeted protections. So again, that whole idea that maybe we just need a conservator to locate and dispose of assets and apply for benefits with Medicaid. And then after that, they don't need to be around anymore and we can dismiss them after that. Or same thing with the guardianship side. Maybe we only need a limited guardianship for the purpose of getting them into an appropriate care setting.
But they can walk away, right?
Yes, they could, just like anybody else in a resident in a facility. So, yeah. But again, it's one of those alternatives. That's the whole point, is that we're trying to give more tools to utilize as potential options before having to seek full or limited ongoing guardianships. Grievance and removal. So making it more robust, that any interested party can file a grievance with the court. The court must review and investigate the report. The court can order additional reports or hearings or initiate removal of a guardian or conservator, and may appoint an emergency substitute appointee for up to 6 months while that removal is pending. And if there is somebody who's just constantly filing grievances, if there's been previous similar grievances filed, the court can decline to act if they have reason to believe that this is just duplicative and it's already been addressed. And that's it. Whew, it's 1:11. I know where people want to wrap up and head out. So unless anybody has any other questions, thank you very much. And I'm sure we will be getting more information as we get into the details of it over the next several months.
Are you sending that out?
I was just.
Yes, I will share this with Heather McDaniel and she'll email the presentation out now. Heather McDaniel, yet another Heather.
Another Heather.
Yes.
Well, at least I'll remember the name.
Heather McDaniel is our
Yeah.
administrative